the explanations exactly what is a judge alone trial. And we have students present. I will take some time to explain exactly what the bill entails. A judge alone trial, Mr. Speaker, is a trial in which a judge sitting alone determines questions of fact and law and is empowered to determine the guilt or innocence of an accused person. Now, judge alone trials, Mr. Speaker, they've been around for a very long time. It's not something new. There are countries in the world that do subscribe to judge alone trials. England, Wales, Northern Ireland, Canada, New Zealand, some of the Australian states, New South Wales, Queensland, Western Australia, the United States of America, India, South Africa. Here in the region, we have Antigua and Barbuda, Jamaica, St. Kitts and Nevis, Cayman Islands, and Belize. Now, why judge alone trials? Why would you want to proceed with a judge alone trials when traditionally we have a judge and a jury trial, which have been around for 800 years? Why do you want a judge alone trials? Well, judge alone trials would be suited for certain types of cases. You may have a high profile case, a serious case, a murder trial, a long and complex case which involves technical evidence. You may have a case which engenders pre-trial publicity. Graphic evidence may be led in a trial. You may have allegations of intimidation or threat to jurors or bias. So you may want to have a judge alone trials. Of course, there have been skeptics as to judge alone trials. And even myself, coming from the defense bar, when I first heard of judge alone trials, I was a bit skeptical because I like the judge and jury. But over a period of time, you get into it, you realize, yes, it's something that I would consider, and I could see the benefit to the criminal justice system of St. Lucia in terms of the reduction of the backlog of cases. Now, I want to put on the record, Mr. Speaker, that the criminal division of the High Court continues to struggle with a significant backlog of criminal cases, and they are unable to dispose of those criminal cases in a timely manner. On average, cases get stuck in the system and may take a couple of years before actually coming to trial. The statistics that have been conducted suggest that countries that have introduced judge-alone trials have seen a significant reduction in those cases. Now, in the bill, we have put the election, the defendant can elect to be tried by a judge alone. So he has that option to say yes or no. The consent of the defendant is required. Now, we have left it wide open in St. Lucia, wide enough to cover all indictable offenses. That scenario exists in Trinidad and Tobago and the Cayman Islands. In some jurisdictions, there's a schedule which provides some offenses to be tried by judge-alone trials. For example, some jurisdictions may say larceny, receiving stolen property, fraud offenses, corruption, possession of firearms, drug offenses, unlawful possession. They suggest in a schedule some of those offenses should be tried by judge alone. They don't want all the offenses. But in St. Lucia, we've decided to elect for all the offenses. Of course, the prosecution themselves may apply to the court for a judge-alone trial. The prosecution may consider that a particular case, in that particular case, there's a danger of jury tampering, intimidation of witnesses, a material witness is afraid or unwilling to give evidence before a jury. The case itself involves a criminal gang element. They make that application to the court for a judge-alone trial, or the complexity or the length of the trial is likely to be burdensome to the jury. So the prosecution may make an application to the court to basically have a judge-alone trial. In our scenario, if the prosecution decides to do that, of course, both sides can make representations to the court. The prosecution would say, yes, this is the reason. The defense would have the opportunity to say no. Now, there's nothing to fear a judge-alone trial. The structure of the trial by judge alone remains the same as the trial with judge and jury. So you have your opening speech, prosecution calls the witnesses, defense cross-examines, you have the close of the prosecution case, If the defense decides to make a no-case submission, that continues. If rejected, the defense is called upon to answer. Defense may be entitled to testify or remain silent. You have addresses and a decision by the court. The same rules of evidence apply. The judge addresses the issues of admissibility, and of course the parties, prosecution, defense, may be called upon to make submissions, argue any legal issues that may arise. Now, the judge, on the conclusion of that judge alone trial, the judge delivers his decision for either the conviction or an acquittal. Now, the judge is mandated to deliver his decision and give a written judgment stating his reasons. And I address the court, Mr. Speaker, the attention to section 923 at page 14 of the bill, which basically says in St. Lucia, the judge is mandated to deliver that written decision within 24 hours. And of course, that written decision would include the principles of law, the findings of fact on which the judge relied upon. Of course, if the judge fails to deliver his decision within the specified period, he should inform the parties that he required of the time required for the completion. And of course, nothing has changed in relation to criminal appeals, powers of the Court of Appeal, same powers in relation that the court has in relation to judge and jury, court has in relation to judge alone trials. And again, in the region, Antigua, Barbuda, Belize, Cayman Islands, Jamaica, St. Kitts and Nevis, Trinidad and Tobago have judge alone trials. What are the advantages of a judge alone trial? Why would you want to have judge alone trials, apart from reduction of the backlog statements, cases, tendering of witness statements, expert evidence, the deliberation process is streamlined for counsel, no risk of disruption from absent jurors, flexible sitting hours, streamlined cross-examination, reduces the backlog, creates a more expeditious criminal justice system, saves expense, may be best for long and complex cases. Jurors may be influenced by improper evidence, even if the judge tells them to disregard it. Guards against the jury's exposure to pretrial publicity. Less formal, making it feel less intimidating than jury trials. Avoids prejudice that a jury may bring to the trial process. Race, gender, religion, gruesome nature of the crime, impartiality, no diversity. And of course, some defense lawyers may say, you know what, I've lost the opportunity to address the jury. Defense has lost the opportunity to address 9 or 12 persons. You have the judge, so all the histrionics you may have before the jury, you don't have that before a judge. The judge is impartial, the judge basically deals with the evidence. That's one of the things that I myself was a bit concerned about. I like addressing the jury, but if you're addressing a judge, a lot of whatever you may say to the jury, the histrionics, as Justice Saunders once said, you do not have that before a judge. The judge is basically just strictly facts and law. Now, the fear of more convictions under judge alone trial, I want to dispense that. The statistics suggest in New South Wales that between 2009 and 2014, there were higher acquittal rates for judge alone trials. And of course, again, advantage, no jury expenses, streamlined opening closing address, and trial less likely to be aborted. Now, in our bill, we've put a particular provision in our bill that emanated from, that was raised, and we took note of it in the case of Sean Campbell and Adidja Palmer, Vibes Cartel, which was delivered in the Privy Council in 2024, 15th of February 2024 at the UK Privy Council. Took note of that at paragraph 54, where there may be a danger in long trials, long and complex trials, the danger of deliberate attempts to derail a criminal trial, in particular at the closing stages, by the defense, by engendering situations in which it becomes necessary to discharge the jury. So you have a long and complex trial, months of evidence taken, months of court time has been invested in a particular trial, and then jury tampering occurs you don't have the provision, basically you have to start all over again. In England and Wales, there is legislation that provides in certain circumstances it is permitted to discharge a jury because of jury tampering and to continue the trial without a jury, but by the judge alone. We looked at that particular ruling in terms of England and Wales, and we have incorporated that in our legislation to avoid a situation like that. New section 974A, discharge of jury as a result of jury tampering. It's at page 11 of the bill. Section 974, page 11 of the bill. Now, I recently attended an inaugural Attorney General's Roundtable discussion in Barbados, where judge-alone trials and plea negotiation featured. And they were both discussed because they provided viable solutions to the challenge of case backlogs in the criminal justice system. My colleagues, we all discussed it. St. Kitts and Nevis, Barbados, Guyana, Dominica, we all discussed judge-alone trials. And I've said a lot of the colleagues at St. Kitts, Barbados, I think, has had only 2 judge-alone trials. St. Kitts has, they have it. Guyana, I think they're looking to introduce it. And as a result of that engagement, I want to thank the facilitators who basically helped us, the material. I want to put on the record and thank Honourable Madam Justice of Appeal, Alice York Suhan, President of the Court of Appeal, Turks and Caicos, and the Honourable Madam DPP, Paula Llewellyn, Senior Counsel from Jamaica, for the resource material, the presentation, which I'm using it as part of my presentation here today, to thank them for their input, and I want to thank them for the guidance in basically assisting us in presenting this particular bill. And I also want to thank all the relevant stakeholders for their input and the guidance in the drafting of this bill. And of course, for their patience. It's something that we wanted to do, but we wanted to get it right. We wanted to get the sections correct. So I thank the stakeholders for their patience. And Mr. Speaker, I conclude, and I ask this honorable court, this honorable house, to give due consideration. I guess I missed the court. I ask this honorable house to give due consideration to this bill. Thank you, Mr. Speaker.
Honourable members, the question is that the Criminal Code Amendment Bill be read a second time. Member for Castries Central.
Thank you very much, Mr. Speaker. Oh, a new day has dawned right here in the city of Castries, led by a government with foresight. Mr. Speaker, I sit in my little space as the member to my right normally says, and I must say I want to commend those persons who put their thoughts together to at least bring a sense of expedition to the dispensation of justice in this country. Mr. Speaker, whilst the Attorney General was basically disseminating the information from which this bill unfolded, it dawned on me that one time, Mr. Speaker, there was a guy called Charles Pistache. He was arrested for murder, Mr. Speaker. And I walked to court on no less than 20 occasions. I was not his legal representative, but I walked to court on about 20 occasions and saw him there at the BS of the court. And all the prosecution said was, "Your Worship, we are not ready to proceed." And he was further incarcerated. Not even to mention, Mr. Speaker, the times when I probably was absent when the similar treat applied. One day, my mother always taught me, Mr. Speaker, check for the less fortunate. He had not paid me 1 penny, and I stood on my feet for about 2 hours, and I walked out with Charles Pistache. Because the whole synopsis was, there was an urge to arrest and then investigate, which means the cart was placed before the horse. And it was on that basis I was able to have the accused discharged. You see, I say all of this, Mr. Speaker, to tell you of the hurdles that our legal system, the hurdles that our system is inundated with, that prevents expeditious hearings and leave persons in prison incarcerated. Lord Denin once said, remand is a fanciful name for imprisonment. So whether you're on remand or you penal, you're in jail, and that's the harsh reality. You're in jail. And so, Mr. Speaker, sometimes the longevity that it takes to dispense justice, that in itself is an injustice. So I welcome this bill, Mr. Speaker. What the Attorney General should have told us, what is happening here, Mr. Speaker, is a replication of exactly what obtains in the magistrate's court. A magistrate is an arbiter of fact and make pronouncements on law. Sadly, in the High Court, the judge is the arbiter of law and the jury would be arbiter of facts. Now, Mr. Speaker, look at how obscene, if you want to call it that, a scenario can be. Let's say lastly, you steal $5,000, $4,500, they say it's a summary matter. So a magistrate can hear you by him or herself. But you top it up to $5,500, $1,000 more. And then they'll tell you it's an indictable matter, triable by judge and jury. You need to have police officers going on motorcycles looking for jurors left, right, and center. Some of them, they don't want to come to court because they fear ramifications of their presence in a criminal trial. Then you have bench warrants issued for jurors who don't turn up. So basically the ramifications and all of the rigmarole attached to judge and jury trial, Mr. Speaker, is what has caused us to be extremely dilatory in the dispensation of justice. So I really welcome the amendment to the code. I welcome, Mr. Speaker, everything that is in there, especially the fact that the judge will be arbiter of both fact and law, which is what obtains currently in magistrate's court. So there is absolutely no difference. You charge under the Firearm Act and they tell you based on the caliber, it's a high court matter or indictable matter as it is legally referred to. So it's an indictable matter, but if it's a caliber or two lower, it's a summary matter. I don't understand why such a fundamental difference in going through a trial for the very object or transgression, because the item is just a little more powerful than the other. So I welcome that. One of the things I did not see in that act, though, Mr. Speaker, and I speak from a standpoint of being a defense lawyer for a very long time, and I dare say a very successful one at that. Mr. Speaker, what the criminal code had made provision for was pre-trial negotiations. And I can tell you, any party to proceedings in criminal proceedings would prefer the expeditious dispensation of the matter if a balance can be struck. So that you call the prosecutor, defense counsel goes with the magistrate, and you say, look, it was this, it was that, what is your likely sentence? Without necessarily clouding the mind of the arbiter. And then you could say, okay, my client, I wouldn't give, if we go down that road, he'll get 3 months rather than a year. You go back to your client, and that can be done and arranged. So that is the only loophole, Mr. Speaker, that personally I would encourage to be incorporated in this amendment so as to facilitate an even more expeditious dispensation of the matters of criminal matters in our jurisdiction. But I support the amendment to the Criminal Code. Thank you, Mr. Speaker.
Member from Mico South.
Thank you very much, Mr. Speaker. Thank you very much, Mr. Speaker. I certainly want to rise and indicate that this was a very clear direction that the former government under my leadership was already proceeding in. I know that consultations had already begun on this issue, and that is why it's very easy for me, Mr. Speaker, to rise today to support this motion. This is a very important step for St. Lucia. We've seen the backlog of cases, and while there may be great expectations that a judge-only trial is going to help expedite those, I think it will, but I don't think that that's the total panacea that we're looking for. There are some other issues that we now have to resolve. I would say to you that for some of the same reasons that the Attorney General has pointed out to Mr. Speaker, the difficulty with a jury. He uses it in nice language, jury tampering. A member from Cass-Free Central spoke about how difficult it is also to be able to get jurors. That this is going to go a long ways in solving that problem. But, Mr. Speaker, as we found out ourselves, this is going to put now a tremendous pressure on the integrity and the ability of our judges. Now, we should not be heartened that a person always has an appeal if they're not happy with the decision. So, we have heard horror stories in the past of jurors being threatened, some jurors being injured, and sadly some jurors yielding to the temptation of what the alternative is. And this is not beyond our own judges. And while we have, Mr. Speaker, through the special branch, security for our judges, I think that this is something that the government is going to have to look at very seriously. I know certainly when we were in office, surveillance cameras at judges' homes, having constant security and a beef up of that entire process is absolutely required, because we're now putting the burden of the decision very much on the judges. And I wish we lived in a better society in which we would not have to concern ourselves with those issues. But these are issues that we're going to have to concern ourselves with. So the opposition wholeheartedly supports these amendments and that we're moving in this direction. And I want to thank members of the party, particularly the delivery unit, that were very involved in getting this off the ground. And I welcome the fact that this government has continued those efforts and has actually brought this document to the House so we can put it into law. So congratulations, and I think that the people in my constituency are grateful, because I know a lot of persons did not like being on juries. I also think that there are persons whose family members have been either robbed or, sadly, worse than that, murdered, and want to see a faster trial. And I think that this is going to, in its own way, help bring that kind of relief to those persons in my constituency, and I dare say to many other constituencies throughout St. Lucia. So I welcome this, and we fully support it, Mr. Speaker. Thank you.
Attorney General.
Mr. Speaker, well, I want to thank members, and I want to thank the opposition for supporting the amendment, and ask that, Mr. Speaker, that the bill be passed, Mr. Speaker. Thank you very much.
Honourable members, the question is that the Criminal Code Amendment Bill be read a second time. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Criminal Code Cap 3.01.
Clause 2.
Interpretation.
Clause 2 stands part of the bill. Clause 3.
Amendment of Section 774.
Clause 3 stands part of the bill. Clause 4.
Amendment of Section 873.
Clause 4 stands part of the bill. Clause 5.
Substitution of Section 874.
Clause 5 stands part of the bill. Clause 6.
Insertion of new Section 874A.
Clause 6 stands part of the bill. Clause 7.
Substitution of Section 892.
Clause 7 stands part of the bill. Clause 8.
Amendment of Section 921.
Clause 8 stands part of the bill. Clause 9.
Amendment of Section 923.
Clause 9 stands part of the bill. Clause 10.
Insertion of new sections 974A and 974B.
Clause 10 stands part of the bill. Clause 11.
Insertion of new sections 998A and 999A and 998B.
Clause 11 stands part of the bill. Clause 12.
Substitution of Section 1018.
Clause 12 stands part of the bill. Clause 13.
Substitution of Section 1019.
Clause 13 stands part of the bill. Clause 14.
Substitution of Section 1020.
Clause 14 stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Honourable members, the question is that the committee rises and the bill be reported. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Honourable members, I beg to report that the Criminal Code Amendment Bill went through committee stage without amendments. Attorney General.
Mr. Speaker, I move that the report of the committee be adopted and the bill be read a third time and passed.
Honourable members, the question is that the report of the committee be adopted and that the Criminal Code Amendment Bill be read a third time and passed. And I'll put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Criminal Code Amendment Act 2025.
Attorney General.
Mr. Speaker, I beg to present for second reading a bill shortly entitled Supreme Court Amendment. Mr. Speaker, in order to support the amendments made to the Criminal Code, the Supreme Court Act requires certain amendments to give recognition to a trial by judge alone. The Act is amended to modify the definition for the word verdict to include the findings of a judge alone in a trial by judge alone. As a result of this amendment, sections 35 and 36 of the Act are amended to recognize the verdict of a judge alone in a judge alone trial in relation to the determination of an appeal in certain cases, the powers of the Court of Appeal in special cases. Further, section 37 of the Act is amended to allow the Court of Appeal to recognize a verdict of a judge in a trial by judge alone in dealing with an appeal against a special verdict that is allowed under Section 1019 of the Criminal Code. Mr. Speaker, the bill is therefore presented to this Honourable House for its consideration. Thank you.
Honourable members, the question is that the Supreme Court Amendment Bill be read a second time. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Supreme Court Act, Cap 2.01.
Clause 2.
Interpretation.
Clause 2 stands part of the bill. Clause 3.
Amendment of Section 2.
Clause 3 stands part of the bill. Clause 4.
Amendment of Section 35.
Clause 4 stands part of the bill. Clause 5.
Amendment of Section 36.
Clause 5 stands part of the bill. Clause 6.
Amendment of Section 37.
Clause 6 stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Honourable members, the question is that the committee rises and the bill be reported. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Honourable members, I beg to report that the Supreme Court Amendment Bill went through committee stage without amendment. Attorney General.
Mr. Speaker, I move that the report of the committee be adopted and the bill be read a third time and passed.
Honourable members, the question is that the report of the committee be adopted and that the Supreme Court Amendment Bill be read a third time and passed. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Supreme Court Amendment Act 2025.
Leader of Government Business.
Mr. Speaker, I beg that this House stands suspended until 1 p.m.
Honourable members, the question is that this House do stand suspended until 1 p.m. And now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Sitting suspended.
All right.
Of proceedings here in the House of Assembly for today, Tuesday, March 11th. We had a later than usual start, and when the House was brought to order, we heard a statement read by the Honourable Minister for Infrastructure, the Parliamentary Representative for Castries North, Honourable Stephenson King, and he made a statement concerning an electricity bill which would soon be introduced to the House. He described it as being necessary to provide accessible and cost-effective electricity to the people of St. Lucia as well as to businesses. He said it was necessary that the bill be introduced, and he described it as being one of the most advanced when it would be introduced, and a most revolutionary piece of legislation. But to the bills that were presented this morning, we saw the Criminal Code Bill. So Honourable Stephenson King was followed by the Attorney General, who presented the Criminal Code Bill. And he said the purpose of that bill really was to reduce the backlog of cases. And what this bill seeks to do is to introduce a trial by judges, have judges-only trial to complement the trials that we're used to, a jury of your peers. And so he said in order to reduce the backlog of cases, this bill by judges alone, a judge alone trial, would really speed up the process of administering justice to cases and getting rid of the backlog of cases that presently sit on the courts. He was supported by the Honourable Parliamentary Representative for Castries Central, the Honourable Richard Frederick. He was followed by the Parliamentary Representative for Lakewood South, the Opposition Leader, Honourable Alan Chasney, and he also gave his endorsement for the bill. He said that it was something that his government was working towards, and he was so pleased that the government had brought it forth. And the second bill that was presented was presented again by the Attorney General, and this bill sought it was called the Supreme Court, and it was ready to supplement the Criminal Code Amendment. And that bill, the Supreme Court Amendment, really was to just alter or to include the meaning, or change the meaning of the word verdict to also include a verdict by a judge. And so the Supreme Court would also recognize verdict by a judge alone trial to complement a trial by a jury. Michael?
Oui, Virginie, merci un peu. Cette liste encore, nous avons des bonnes après-midi. Nous commençons, Virginie, nous en Caïconsit avec nous commençons session ça là bien tard aujourd'hui. La dernière raison pour ça, mais moi je suppose expliquer qui dit exactement pour qui raison il commence à dire tard. C'est raison nous apprendre. C'est la dernière des changements qui étaient pour faire à ce papier. Ça nous a créé order paper, nous a créé en anglais, ça c'est agenda pour discussion pour suivre en Caïconsit. Comme vous dites, nous commençons cette session aujourd'hui avec un statement par le ministre qui est responsable pour les affaires, gros projet, avec aussi électricité, avec différents statements à ce policy gouvernement qui a échangé en ligne de courant électrique, avec qui dit comme que là nous avons un changement particulièrement avec un service différentes qualités courant service vent différents bagages pour faire courant en payant avec il dit ça a commencé tout de suite avec aussi et après ça la dernière président Sali a créé bill ça c'est loi gouvernement qui a changé c'était qui était présenté par un avocat gouvernement qui parlait à ce un changement, gros changement qui a fait en loi quand même ça nous a créé criminal code, ça veut dire côté un juge. Normalement mon habitué en gros cas c'est juge la gagné, ça a créé jury avec ça quand les causes un pile problème qui chaîne case en chaque case derrière avec gouvernement comme avocat gouvernement dit, l'année plusieurs l'autre place en la terre avec un Kawaïd là qui fait changement ça la côté juge ça fait jugement avec cette aller en direction ça là puisqu'il y a une cause en chai il prend moins de temps pour faire en chai ces cases là avec Honourable Richard Frederick même parlement pour Mittenville Castries il supportait malgré il dit puisqu'il dit il fait justice aller plus vite avec mais il aussi noté comment un avocat même il dit l'année en bagaille qui il était noté fait ça en bagaille qui pre-trial negotiation ça veut dire après de l'année certaine manière ça fait négociation avant juste la fête pour faire bagaille plus à l'aise toujours aussi même parlement pour Soudnikou qui aussi c'est chef opposition face à l'opposition et aussi supporté ça c'est bien là avec dit comme que le gouvernement était déjà regardé en direction ça là avec ça c'est un bon bail mais aussi il dit en l'autre bagaille il aussi mentionné qui c'est en cas côté l'Algérie il y a chaque délai moun qui a menacé moun qui a fait ça en chaque délai c'est moun qui a servi quand je pas de faire ça encore et toutes ces bagages ça là qui tiennent ces cas ça là avec ces pour raison ça là qui fait il a supporté malgré il dit aussi qui il croit en loi gouvernement pour mettre plus de sécurité pour ces juges là puisque comme ces juges qui a fait ces bagages là aussi la tenir l'autre bill qui Virgil mentionné aussi qui gouvernement passé aujourd'hui ça c'est un autre qui Supreme Court mais c'est un cas complémentaire ça il a complémenté sa première code criminel là pour changer un des noms qu'on veut dire quelque bagaille comme ça qui passait assez vite c'est comme ça il passait avec ça s'explique avec un conseil décider, il y a un petit moment avec nous qui décider, il y a vivre, puisque comme on dit en commencement, la tenir un petit problème et puis un changement, amendement avec un autre bill qui pour passer ici, avec ces raisons qui fait, ça va créer
Sovereign Wealth Fund.
Sovereign Wealth Fund. Ça c'est une loi que le gouvernement a passé pour mettre en réserve l'argent à sous-côté pour aider le pays, particulièrement en cas de désastre avec des bagages comme ça. Bon, c'est ça qui tient session en retard, puisque c'est speaker a dit la tenue antibiotique pour agir. Quand nous avons parlé là, nous avons c'est travail parlement qui a passé, puisque le changement en fait avec Issam, nous dévier, nous avons préparé pour discuter.
Yes, so join us again. We return here at 1 o'clock for the continuation of today's session.
That is really tough.
Out who the extension officer is for the Groseley constituency, the individual whom the very same farmers have indicated to me as parliamentary rep